our latest ALTA Insights webinar. I'm Jeremy Yohe, ALTA's Vice President of Communications, and today we've got a fantastic presentation lined up to discuss RESPA compliance and hopefully help you better understand the difference between a referral fee and a fee split. And we'll also get into what compensation is permissible under the law. Definitely a lot of interest in RESPA compliance these days. We had more than 500 people register for today's webinar, so hopefully you all find the content informative and helpful. Before starting, I do need to touch on a few housekeeping items. The webinar is being recorded. You'll get an email tomorrow with a link to the recording. There'll also be a link to download a copy of the presentation. And you can always access all of our webinar recordings at alta.org/webinars. That's alta.org/webinars. We do have the speaker also provided an extra document. There's a CFPB facts document that pertain to RESPA compliance in the handout section, so you can download that as well. And if anytime you have a question, please submit them in the questions box. We'll hold some time at the end for Q&A. And as a reminder, today's webinar is offering CE and CLE credit in many states. Credit's only available if you're attending this live presentation, and our platform does track attendance. To meet state compliance, we'll have a few poll questions during the webinar monitoring your attentiveness, so no multitasking out there. For any questions regarding CE, CLE, send an email to education@alta.org. I do need to thank AccuTitle for sponsoring today's webinar. Before introducing today's speaker, here is a short message from AccuTitle.
We at AccuTitle offer title management platforms to empower title professionals to close with confidence. Our house consists of brands you may already know: Closer's Choice, LandTech, Tracker Pro, and Title Fusion, AccuTitle's cloud-based platform. We offer solutions to make the intricate real estate closing process more manageable. We combine the vast integration network developed by Closer's Choice with the renowned title experts from LandTech and the end-to-end title production and accounting package of Tracker Pro. Together, paired with the highly customizable solution offered by Title Fusion, we are confident we have the right technology for you. All of our platforms offer a streamlined experience with robust capabilities and integrations. Partner with us today and close with confidence.
All right. Well, thank you, AccuTitle, for that message. With that, let me introduce today's speaker. Join us today. We are fortunate to have Richard Andriano Jr. Rich is the practice leader at Ballard Spahr's Mortgage Banking Group. He has more than 30 years of practice experience in the areas of financial services, mortgage banking, and consumer finance law. Rich advises title companies, banks, lenders, brokers, home builders, insurance companies, pretty much the whole gamut of real estate professionals and other settlement providers on regulatory compliance and transactional matters, FHA issues, and administrative examinations, enforcement actions, and investigations. So Rich has definitely knows our business, knows the title and settlement business, and partnerships with real estate agents and lenders. So Rich, with that, I'll turn the presentation over to you.
Thank you very much, Jeremy, and a good day, everyone. Well, here's what we'll be covering today. First, how did we get RESPA? I'll go into that and its scope. Then some of the Section 8 basics, the referral fee and fee splitting prohibitions, relatively brief provisions, but obviously very important provisions for our industry. Then a number of the specific exceptions to those prohibitions. So without exceptions, the industry couldn't function because of the broadness of the prohibitions. And there is a title company specific one, and particularly we'll focus on a general goods, facilities, and services exemption. In fact, a lot of people actually rely on that, perhaps without knowing that they are, to be compliant with RESPA. And we'll touch on the affiliated business arrangement exemption, commonly relied on by joint ventures between settlement service providers. Then, as I said, we'll go a little more in depth on the good facilities and services exception, some unfortunate guidance that the Bureau issued that mercifully was withdrawn, and then some more helpful guidance that they issued, perhaps not as detailed as the industry would like, but nonetheless helpful, I think, in particularly addressing two topics. One is there is a regulatory gifts and promotional activity exemption from the Section 8 prohibitions. And then they touch on the famous issue of marketing services agreements. And as we get to the end, you'll see where I think it's helpful for compliance is to think more in terms of advertising rather than marketing. That'll be helpful. So with that quick overview, let's get started. We'll move on to the next slide, and what we will see is when we got RESPA, it was adopted in 1974, became effective in 75. The reason why we got it is because not only did Washington Post investigative reporting include the Pentagon Papers and Watergate, they also found out that title agents would pay real estate agents for referrals of business. Now, notwithstanding that, that's a very common practice, business to business, consumer business matters, that referral fees were paid. Nonetheless, Congress was absolutely mortified by this and decided to pass a law prohibiting in the settlement service industry referral fees. It's interesting. As we'll see, one of the keys is that there's a loan term the statute uses as federally related mortgage loan, and there was initially an issue whether loans were actually covered, and that was later clarified that they were. Now, the initial regulations, known as Regulation X, was adopted by the Department of Housing and Urban Development. That's where Congress originally placed RESPA, figuring it was probably, since it was a housing real estate related type statute, rather than give it to the Fed, which had truth in lending and other consumer financial protection laws, they gave it to HUD. But when Dodd-Frank came along, as with many other statutes and rules, RESPA and Regulation X moved over to the Consumer Financial Protection Bureau, or CFPB, as we refer to it in short. Now, originally, RESPA was much more limited in the transactions it applied to. Still involved financing, but the types of financings were more limited than they are today. Now, again, the statute uses the term federally related mortgage loan. That's extraordinarily broad in its definition. So pretty much any finance transaction involving residential real estate, you're going to have RESPA being applicable. And this is purchase money, refis, home improvement, home equity, both open end and close end. I noticed a home equity for open end, home equity lines of credit. They are exempt from a number of the RESPA disclosure requirements if they are subject to the Truth in Lending Act disclosure requirements. That leads a number of folks to incorrectly believe that HELOCs are not subject to RESPA, and actually they are. They are subject to RESPA, and particularly Section 8. They're just not subject to the referral fee, the certain disclosure provisions, but they are subject to the referral fee and fee splitting prohibitions. That originally wasn't the case. That's another source of confusion. And it doesn't matter if it's a first lien or a junior lien. So pretty broad. If you're dealing with a 1 or 4 family property and there's financing, best assumption is RESPA's applicable to that transactions. Now, there are a few exemptions. Again, business purpose transactions, and for this, you could look to the guidance under Regulation Z, and particularly in the commentary. What's particularly helpful there, it has some very specific guidance on investment property loans when it involves a purchase or an improvement. Oddly, refinance is just determined whether the loan's primarily personal primarily business. But for investment property loans, there's actually a bright line that if the consumer won't live in the home more than 14 days in a year, they're using the IRS concept of rental, what's active rental property, then you could treat it as a business purpose loan. Other business loans as well. Temporary financings they wanted. So a construction only loan, not a construction to perm, that's not a temporary, but a construction only loan, but they put a cap, has to be less than 2 years. Bridge loans, someone gets a loan on their existing home to buy a new home, and it's only meant to be, out there for a month or two. And loan on vacant land, the tenants to have a dwelling, unless with the proceeds of that loan, there will be a home constructed or placed on the land. That would be a permanent loan, not a construction only loan. In the next 2 years. And people say, well, placed on, I said, think manufactured housing or something like that. That would be placed on the land. Now, so that's RESPA, how we got it, what its scope. Let's move on now to the substantive provisions on the next slide. And here we have the two main prohibitions, the referral fee and fee splitting prohibitions. As you can see, they're relatively brief. Yet notwithstanding their brevity, they have gotten an awful lot of attention since they became effective. And the first, the referral fee is it's two-sided. No person may give and no person may accept a kickback, other thing of value that business incident to or part of a real estate settlement service involving a federally related loan will be referred to any person. The referral, often referred to as the referral fee or kickback prohibition. Sister prohibition, the fee splitting prohibition. Again, it's no one may give and no one may accept, so it's both parties. A split or percentage of any charge made for a settlement service in a transaction involving a federally related mortgage loan, other than for services actually performed. So here we actually have an exception in the prohibition, whereas we have separate exceptions for the referral fee prohibition that we'll get to. This is for services actually performed, you can get a fee split for that. And we'll go into a little more of the tortured history of the fee splitting prohibition. But let's now move on and take a look at the tortured history, as I mentioned. In Reg X, which is now, once was with HUD, now with the Bureau, HUD sets forth its view, and it's still there sitting in the reg. How much is still effective, I think one could question. But it says a charge for a person for which no or nominal services are performed, or for which duplicative fees of charges an unearned fee and violates the fee splitting prohibition. What HUD often would say, and you're seeing is, well, RESPA prohibits unearned fees. I said, no, you say it prohibits unearned fees, HUD. What Congress said is it prohibits referral fees and it prohibits fee splits. If Congress wanted to say it prohibited unearned fees, which is different, it would have said that. It did not say that. But this is the HUD view that they tried to use under the fee splitting prohibition and get into the rule. The duplicative fees concept refers to, and this is a little different, it's if you're already in a transaction performing a service, you can't effectively perform the same service in a different context slightly and then get paid twice for it. It's really, if you want to get paid twice, you have to perform distinct services that are necessary and to the transaction and in fact actually performed. HUD took a chance, it took an opportunity when it had a chance. Pretty much Congress directed it through lobbying from the industry to provide more clarification that would help address those who might remember the yield spread premium lawsuits of over 20 years ago. So it issued this statement of policy to do that, but it took the chance at that point to set forth its broad views regarding the fee splitting prohibition. And it said the prohibition actually prohibits 3 separate activities. 1, 2 or more persons split a fee for settlement service, any portion of which is unearned. That to us in the industry, okay, that's the fee splitting prohibition. That's that. Okay, we get that. Now here's where we thought HUD went off the rails. It had always taken the view that if one settlement service provider marked up the cost of another provider's fee and didn't render any actual necessary or distinct services for that, that violated the fee splitting prohibition. In other words, single party contact even though it involved a third-party fee. Now, you would get some people that would mark up a fee, but they were performing a corollary service associated with that, and rather than charge a separate fee, they just increase, the main fee of it, partially for their work, and the rest they passed on to the settlement service provider. But HUD thought that this violated the fee splitting prohibition, and we, the industry, didn't think you could get there. Then they went even farther and said, well, it's also violated if one provider charges the consumer a fee where no nominal or duplicative work is done, or the fee exceeds the reasonable values of goods, services, or facilities provided. In other words, HUD says, they don't think I did enough to earn the fee, or I just charged too much for the fee. Now, I've looked back and forth under RESPA and never seen anything that indicates it's a rate-setting statute, but that's clearly what HUD was trying to say, that RESPA is a rate-setting statute by doing this. The industry didn't initially challenge this position because there was some yield spread language in the statement of policy that the industry liked, so it didn't want to take the statement of policy down. I argued there are two different parts of the statement of policy. We could sue this one, not the other one. And finally, the industry started attacking it, and it got on up because plaintiffs would rely on these provisions to say why certain things weren't permitted, and the industry would defend. Gets up to the Supreme Court in 2012, and basically the Supreme Court got it. It was a 9-0 decision. So this wasn't a liberal or conservative issue. This was clear an issue where HUD was way overextending what the prohibition actually prohibited. And they said, no, it only prohibits actual fee splits between two parties, rejecting the two other points from the statement of policy. Now, what I point out though is, remember, RESPA is not the only law that's out there, and because I had some people immediately say, "Oh, can we mark up fees now?" And I said no, and it was in fact during the oral arguments. I remember it was Justice Scalia was leading the questioning, late Justice Scalia, and you always had to be careful because when he asked a question that seemed simple, it was always, was he laying a trap or not? So he asked the counsel for the lender, well, if we rule that RESPA doesn't prohibit markups, because they thought there was some concern with that practice. Is there no other law available to challenge the conduct? And the attorney thinks a moment, is it a trap? No, I think it's a straightforward question. Said, well, yeah, there's state law. And then Justice Scalia said, yes, there's state law. And there's also federal UDAP law. So while RESPA doesn't prohibit markups, a lot of other state laws do, and obviously we know a lot of times title fees, there's significant state regulation, so we have to be careful there. Now, I think, Jeremy, do we have our first polling question coming up?
We do. Let me get that launched here, make sure everyone's still paying attention who needs CE/CLE. So, question that's that is related to the topic. Real estate agent hosting a group of clients for a golf tournament. They ask the title company to sponsor a hole. Is this okay? Let you a few seconds here to get everyone to answer. Well, Rich, it's about neck and neck between yes and depends. We a few more seconds here. 15% saying no. All right, we'll close it. It's about 42% yes. 43% depends. And the answer is depends. Probably okay if the title company puts up signage at a hole, be present at the tournament, paying fair market services. So, all right, good job for 42% of you that got depends, and the other 42 that said yes. All right, back to you, Rich.
Very good. Now, let's look at some of the specific exceptions or exemptions that were built into RESPA. The referral fee and fee splitting prohibitions, very broad. So the industry can't work without these exceptions. One is title company specific, where the prohibition shall not be interpreted to prohibit a title company for compensating its duly appointed agent for services actually performed in the issuance of a title policy. Because obviously, title agents refer business to title underwriters, but they also perform services. So that's what this exception was managed or designed to cover. Now, HUD had interpreted that. It had some prior interpretations, but finally put it in a statement of policy. And while technically the statement of policy applies to practices in Florida, HUD would say, in general, we think this pretty much is of universal application. Only variances would depend on if state law that might vary what's a core title service. And here what they said, in their view in Florida, what was a core title service, and here's what the thing is, to be within this exemption, you have to perform core title services. That's how they were interpreting it. And it was evaluating the title, looking at all the title evidence and everything to decide whether you could in fact issue a commitment and what exceptions might be in that commitment. Then to prepare the commitment itself and identify any exceptions to it that you wouldn't want to insure over unless they were somehow cleared. To the extent the title underwriter would have objections to anything that was found in the record, that those would be addressed and you'd clear any issues. And then finally get ready to issue the policy itself. And if this was something that was done as part of the duties for the underwriter, also perform the closing. We know while title agencies often perform the closing, often that's a separate service that they're performing for the parties to the transaction and not necessarily for the title underwriter. So that is a specific title company exemption. Now let's move on to one that the way it's drafted actually is not relied on that much. This is a lender-specific exemption, but it is a payment by a lender to its duly appointed agent for services actually performed in the making of a loan. Well, most of the time you have a mortgage broker, if it's not the lender, and brokers almost universally are independent contractors and not agents. So while this exists, the exemption exists, it's really not relied on that much. And HUD did provide some guidance, and the guidance remains valid today in terms of, because again, like a title agent sends business to an underwriter, a mortgage broker sends business to a lender. So in cases when the broker was getting paid by the lender, because sometimes they get paid by the consumer, this addressed the minimum services they had performed to get anything, and then to reinforce the concept of, and whatever they get, they must be specific. But this wasn't interpreting this exception. It was actually interpreting the goods, services, and facilities exception, which applies to mortgage brokers because they're generally independent contractors. But I note that then they clarify that statement of policy 2001-1, which I had that overly broad fee splitting prohibition interpretation. It also addressed brokers providing services for lenders in that. Now let's move on to the next exemption that exists. And here's the one. Here's the main one that is relied on by a lot of industries, and particularly with marketing services or related type agreements. This is the one. It's basically nothing in the section is to prohibit the payment to a person of a bona fide, and we'll get into the bona fide concept, a salary or compensation other than payments for goods or facilities actually furnished or for services actually performed. So the thought is, even in a referral context, if A is referring business to B and B is paying A, but B is only paying A for services, goods, or facilities that A is performing, then that is deemed not to violate the statute as long as this bona fide concept, which we'll get into, is in fact met. And we want to address something else before returning to this exception. So let's look at the next slide here. Joint ventures, you've heard of them a lot. Two settlement providers often form a joint venture. Sometimes they're, although also where you have home builder, it might have its own title company or lender. Those are affiliate business arrangements. And this exemption originally wasn't part of the statute. And some people who I think had too much time on their hands started thinking is, well, if let's say I'm a subsidiary of someone and they refer me business, my parent refers me business, and since I'm a sub, I dividend up or distribute up earnings. Gee, is that a Section 8 violation? And it started percolating. Was that a Section 8 violation? So Congress stepped in and said, no, that's actually not what we meant to prohibit. But when a referral is made to a related party, maybe that referral is not being done in the best interest of the consumer. So we're going to create an exemption for these situations that allows the payment of ownership distributions. It doesn't consider them a Section 8 violation, but we're going to impose 3 conditions. One is there has to be a disclosure up front at or before the time of the referral with specified information that alerts to the consumer to the relationship between the party that is referring them and the party they're being referred to, and provides some basic cost information. It makes it clear to them that in most cases they are required to use the related party and they're free to shop around. There are some exceptions. As you might expect, there's a no required use prohibition. The disclosure has to reflect that. There are a few exceptions in our area. One that did get worked into the statute is, as you know, a lot of attorneys or law firms are involved in real estate transactions, and they also often operate a title entity either as part of or often more adjacent to the law practice. And there it's allowed. They are allowed to bring in their related title company on matters they're handling. That was an exception built into the no required use general condition. And then in the end, that alluded to beginning, the only thing of value is in fact, other than other RESPA permitted payments, is in fact the return on the ownership interest or franchise relationship, if that's the nature of it. Now, HUD in 1996 issued a statement of policy, and it actually uses the term controlled business arrangements. That's what affiliated business arrangements were referred to back then. They were referred to as controlled business arrangements, and that got changed some years later. Still applies though. This is still guidance. And basically, even some industry sources were going to HUD saying, hey, we think there's a lot of basically sham arrangements out there where they're just disguised joint venture arrangements that are really shams to pay referral fees. There's nothing. You go to kick the tires and it's a cardboard cutout and falls over. Yeah, there was nothing there. So they issued this indicating, well, if we come upon a joint venture and we start assessing it for Section 8, here are 10 factors that we'll look at to decide, is it a real entity or is it a sham? And then here are 4 factors we'll look at to assess the ownership distributions. And no one of the factors is determinative, though some are more important than others in terms of the formation. Does the entity have its own capital? Is it sufficient? Does it have its own facilities? Does it have its own employees? Does it actually do the main work for which being paid for on its own? Basic things like that. Is it a real entity? That the 10 factors are trying to get at. And the 4 factors regarding distributions is, did people actually invest their own funds? Did the ownership interest they receive reflect that investment? So in other words, it's prorated, or is it more that distributions they bought in cheap, or they get distributions that are more than they should? In other words, are the distributions really sham distributions that are paying for referrals and not just paying legitimate interest on ownership distributions? Now, this did come up in a case some years ago before the Sixth Circuit. And the Sixth Circuit decided it was not going to apply the HUD conditions because they said, well, the affiliated business arrangement exemption is a safe harbor, and a safe harbor isn't much of a safe harbor if a government agency could add conditions to it, was the Sixth Circuit's position. I still think a lot of the HUD, even if you don't follow the guidance as a statement of policy, I think if you can, just under the statute and reg itself, if you're not within the boundaries of the guidance, someone just using the statute and reg itself might be able to get at you in various cases. But this is only one circuit, none other, and it's only 4 states, also Kentucky, Michigan, Ohio, Tennessee. In general, I found the industry, notwithstanding this, takes the view that we're going to follow the HUD guidance because it moved over to the Bureau, and the Bureau appears to follow the guidance. So that's what I see, Gerald, in the industry. Now let's return on the next slide to the general exception that I mentioned before, the 8C2 exception. Again, has the concept of bona fide. And what HUD really has done is said, okay, when you get paid, you actually have to have done something. It has to be worthwhile. It can't be something just nominal. It can't be duplicative of something you're already else done. You can't get paid twice. And what you get paid, just by performing a service, that's not, there has to be some commensurate number, that the number that you get paid reflects the value of what you perform. That's how they read that into the bona fide concept. Now, this exemption is what marketing services agreements were based on. And while some were originally structured quite well, things, as we'll see, got a little out of hand. There was also, though, tremendous lack of guidance. So there were sources in the industry who were asking the Bureau to provide guidance. That was against my advice. I said, this is when Director Cordray was still the director of the Bureau. I said, they don't like marketing services agreements. There's no way they're going to give you guidance on how to do something they don't want you to do. And this is, a case of be careful what you ask for, you may get it. The Bureau issued guidance in the form of a compliance bulletin in October of 2015. It was about as bad as you could get. While they couldn't say marketing services agreements were per se illegal, and they pretty much note they couldn't say that, they basically in the end said, we think you would have a very difficult time structuring and then implementing a marketing services agreement that actually complies with RESPA. I mean, it was just horrendous. It's 5 pages, and I don't refer to it as 5-page bulletin. I refer to it as a 5-page rant, because that's basically what it was. And it addressed other things that weren't even marketing services agreement, but kind of lumped them all in as if they were all marketing services agreements. So then industry sources, particularly when Acting Director Mulvaney and then full-time Director Kathleen Kraninger were in, at the least, Bureau withdraw the bulletin, and it would be nice if you issued more helpful guidance. And it was in 2020, it was finally withdrawn after 5 years of torturing the industry. And we'll get into these a little more, but the FAQs a little later. But what they do is they provide general guidance on the scope of RESPA, the referral fee and fee splitting prohibition. They give general guidance on the goods, services, and facilities exception. And then they address 2 things in particular. There is not a statutory, but a regulatory gifts and promotional activity exemption. And then they address marketing services agreements, which I all think, and it's up. We'll get into that. But before we do, I think, do we have our next polling question?
Yes, we do, Rich. All right. Second and last poll question. Let's launch that here. Can a title company give a real estate agent notepads with the title company's name on them? Just take a few seconds here, and we can share the results and then get back to the presentation. All right, got about 2/3 of you who voted. Hopefully, if you need CE/CLE, you are answering the questions. All right, we'll go ahead and close it. 76%, well, 75% said yes. The answer is yes. 19% said depends. So people seem to have a good understanding of what they can do here, Rich.
Yep, and there's actually specific informal guidance in this area. It was HUD initially came out with it years ago, and then the Bureau kind of in these FAQs actually repeats it. That it's although notepads aren't something of value, that and this is covered by this exemption we're now going to cover, the gifts and promotional activity exemption, where and one of the things is think of when title companies may host a seminar on something, and they'll have maybe notepads or pens or calendars, those kind of tchotchkes that you give out, and it's got the title company's name on it. Yeah, is it something of value? Yes, but it's done as a normal promotional activity, and that was what this exemption was intended to cover. And again, it's actually not in the statute, but it's just in the reg. I was always kind of scratched my head why HUD adopted it, and I think it was partially to account for normal activities that generally occurred. So Here's what the FAQ asks. It's one question: can a lender or other settlement provider give a gift, refund, or discount to a consumer for using that lender or provider? Now, this isn't actually the exemption. This is an informal position. And generally, yes, the FAQs respond. And again, they're attached as a copy. I recommend you download those. Those would be happy. Basically, you could read the referral fee prohibition to apply to giving a consumer something to pick you as title agency. Technically, you could read it that way because there's nothing that says you can't. But both HUD and the Bureau have informally interpreted the statute to mean, well, that's what Congress, they didn't mean to prohibit that. So basically, for RESPA purposes, we'll get to other laws in a moment. For RESPA purposes, you could offer something of value for the consumer to pick you as a provider, and that's okay. And again, it's only an informal position. Key here is a lot of people mistakenly think that there's a consumer-based exemption, and it's not really. It's only the consumer who's hiring you. You can't pay one consumer to refer another consumer. That would violate the provision, and I've run into that where you got some folks who didn't run through compliance and they developed this friends and family program for former customers referring friends and family. And HUD found out about it, and that got quickly shut down. So understand, it's only the consumer who's picking you. Now, with title insurance, what we have to remember is this is one area where it may be fine under RESPA, but it may not be fine under state law because there's a lot of state anti-rebate and anti-inducement laws that actually prohibit you giving something, although to the consumer to induce them to select you for title insurance purposes, although some states have de minimis exceptions, such as perhaps $25 or something to that effect. But here it's important to know not only RESPA, but your state law, because this is one case I often run into. I said, well, you can do it under RESPA, you just can't do it under your state's law, unfortunately. So now let's move on to the next slide. And this is the promotional and educational exemption. Now the past slide we were referring to an informal position. Here HUD actually put something in Reg X. And again, that's the term used, normal promotional and educational activities. It has two conditions when you could give something of value and fit the exception. The act, it's not conditioned on the referral of business. It's just you're promoting yourself, but you're not rewarding someone from having referred or inducing someone to refer. And the activities don't involve a defraying of expenses that otherwise would be incurred by the referral source. Those are the two conditions. Now, the facts say, whether a particular item or activity meets the two conditions, it's a factual question. And that's it with a lot of Section 8 issues. They're often very fact-based, and nuances can mean, well, and this audience seems to get that by saying depends. That often is the answer. And the FAQs actually get into that, where they'll show scenarios that, here's some scenarios where it's probably okay. They wouldn't even say definitely, but probably. But if we make a few tweaks to the facts, then it's probably not okay. The facts actually get into that concept where it does vary. Now, as to the first condition, not conditioned on the referral of business, relevant factors may include whether the item activity is targeted to referral sources. The broader the targeting to referral and non-referral services, more likely you're going to meet the first condition, and how often the activity is given for referral source. Obviously, if something is given regularly, particularly following referrals, sounds a lot more like it's being given for the referral and not meant as a promotional activity. Second factor, no defraying of expenses. Well, relevant factor may be whether the item or activity involves a good or service the referral source would otherwise have to pay for themselves. What's one of the examples that often comes up in the title area is title companies, can they provide continuing education for real estate agents? And the FAQs actually get into this and have a scenario that likely qualifies for the exemption and one that does not. The one that likely qualifies is fairly straightforward. They hold a continuing education seminar people that attend have to pay, so that even the real estate agents have to pay. They're paying the fair market value for that education. And in that circumstance, seems pretty straightforward that that probably would qualify for the exemption. They switch the facts where it's the title company's holding the mandatory education seminar. It does charge a fee. However, for real estate agents that made a certain number of referrals, it waives the fee, and that's pretty clear that that's going to put you outside the exemption and probably into RESPA jail land, as we call it. So again, another reason I commend the facts to you. That not as detailed as the industry I think would have liked, but I think they're helpful as to general concepts. Now let's take a look at the next slide. And here, the famous issue of marketing services agreements. And we'll go into this, and they do address this, and this is where I think this guidance is a lot better than the bulletin, which said, well, not per se illegal, but we really don't see how you could do one legally. This actually tries to provide guidance, and I think the Bureau was pretty even-handed here in the way it did it. Again, maybe not as detailed as some folks would like, but it's hard to get into a lot of detail because, as we know, a lot of times with RESPA, it depends, and it's really fact-specific. And basically, for this guidance, what a marketing services agreement is, it's an arrangement where one entity or person agrees to market another party, a settlement service provider, and for compensation. And they said it can involve settlement service providers, or maybe not. Maybe the other party may not be a settlement service provider or not. But one common one is where a mortgage loan originator agrees to market or promote the services of a real estate agent. Often the arrangement is the other way around, but same rules apply either way. Now, lay down the basic distinction. Look, a marketing service agreement is lawful if it's for the performance of services and is not for, referrals. So if services are performed and the compensation relates to the value of the services performed, then that you may well have then a valid marketing services agreement for purposes of RESPA, and rather than a referral fee agreement. Now, what they do say, if someone is a settlement service provider and they're doing the marketing, here's we get into you can't do the same thing and get paid twice. Whatever the services they're performing in the marketing have to be actual, necessarily distinct from the primary purposes. Ordinarily they would be, because ordinarily someone's primary services is not marketing another party. So but they have to be careful just in what your list of services are to make sure there's nothing duplicative in that. And again, you can't structure it in a way that actually results while not performing services in payment for referrals. So structure does matter. Now let's move on to the next slide. We have a little more depth, get a little more detail on this. This, I think, actually is helpful in the sense of it was a concept I always tried to put forth. I thought it was the correct concept. It's just that neither HUD or the Bureau ever sort of said this is so clear. And now, for the first time in writing, they were putting forth this concept, which I thought was very helpful. Is how do you distinguish between a referral and marketing? Where what's the basic structural difference between the two? And again, they say it's fact specific. They go, but they do try to add some basic context. That a referral is an oral or written action directed to a person that has the effect of affirmatively influencing the selection of a particular provider. Referrals include a settlement service provider directly handing clients contact information of another provider that happens to result in the client using the other provider. And so sometimes we see marketing agreements where they said, oh, I'm paying them for this. I say, you can't pay for that. That's a referral. But again, we'll get to how the industry went down the rabbit hole here. But then the guidance says, but marketing really isn't directed to a person. It's more generally targeted to a wider audience. And here we'll get to why I think advertising is a better way to think than marketing. And here they do, placing an advertisement in a settlement service provider on a widely circulated media. And then it would be more or less getting to a settlement service provider that has some sort of media that has traffic and getting an advertisement in there. I think that probably would have been a better example here. But they're clear if it's just intending to be a payment for a referral, then it is not permitted by RESPA Section 8, simply not allowed. Now, let's move on to the next slide. And here, I think we get a little further, and I could get into some examples and what I think is good. And what would have been helpful if the Bureau went a little further than they did, but I think they were, trying to be careful in not going too far and perhaps painting themselves in a corner that they wouldn't want to paint themselves in. The facts include as well. Give me an example of what's prohibited. What's prohibited? They ask that question, and what they do indicate it's the structure itself can be illegal under RESPA Section 8, or you might have a good structure, but the implementation may be bad. And that's an important concept. That also gets down to the it depends concept. And often where I did see a lot falling short, that the implementation just was lacking, and it would be hard to defend if a regulator had called the agreement into question. And they note that their Bureau of Enforcement had come across many arrangements that they thought violated Section 8 that involved either an oral or a written marketing services agreement. And again, facts and circumstances are important, and it's just not what the agreement says, is what's actually happening as well. When they come in and look, they're going to read the agreement first. The agreement on its face may be bad, but even if the agreement's really good, they're going to see what happened. They said, did you follow the agreement? Did the services actually perform? Did you actually pay what the agreement said or not? And that's where when sometimes they came in and they saw payments that didn't necessarily tie to the agreement, and they figured out pretty quickly they were payments for referrals. So yeah, so implementation is important. So obviously, what's bad? Agreement to pay for referrals. Well, we know that's bad. You can't do that. Here, their services perform, but the payment for those services exceeds the value of the services. There, if it exceeds the value of the services, deemed that excess must be compensation for referrals, is the thinking. You have an agreement, it's great, provides for wonderful services. Trouble is, they don't perform some or all of the services. Obviously, that's not going to work if you have that. Then they also say, or it's just nominal. They're doing so little, you can't pay them, or they're getting paid twice for something. And again, you can't get paid twice. Then they say agreement designed or implemented in a way, and this goes to the situation where I found that, and it was an enforcement where they're looking and they realized, why are these payments varying? They're going up and down or this and that. And they figured out why the payments were going up or down or this or that. It was in relation to the referrals. Now, what I did see with marketing, I was involved in creating, probably was one of the first ones that actually did get reviewed by HUD in a we're not so sure complies context, and that came out fine. We really had done our homework, and the agreement was designed really for promotional purposes. It was not designed for referral purposes, and I think that was the key. Is the goal was promotional, but what I and others finally observed is the industry slowly went down the rabbit hole. Things got worse and worse. Behavior got very aggressive, and I one time was chatting with someone, and they laid out an arrangement where basically the marketing agreement would be nothing more than the real estate agent chatting up a particular settlement provider and maybe giving them some marketing pieces on the provider and getting paid for that. And I said, no, that's not marketing, guys. That's a referral. And the response was, and they actually believe this, was, no, Rich, you don't understand. If we call it marketing, then it's legal. And that's when I knew it was all going to hit the fan. Then the Bureau really started looking at these. There were enforcement actions. States started looking at it. We got that horrible bulletin, which thank God it's been withdrawn, and we got some more sensible guidance in its place. But that was a problem. Now, even with that, where I find a lot of people come to, we want to have a marketing services. So, okay. And I said, what's the marketing? I said, what do you mean, what's the marketing? I said, guys, okay, you came up with a number. How did you get to the number? Well, that's what the brokerage firm wants. Okay, yeah, that doesn't get you there. And where a lot of agreements is they don't have services that are actually compensable services. A lot of them, it's just referral activity. And even if they have good services, then I'm saying, okay, you're going to have an ad. Where's the ad going to appear? On the web page. What part of the web page? How often is it going to appear? What's the traffic on the web page? What size is it? And none of those questions are answered. I said, well, how can you possibly value the marketing? You know, I know banner ads and web pages. Yes, it's markets for that, but there's a way it's marketed. They first say, look, how many people, how many page visits does it get a day? How many people are looking at it? How often does it appear? Where does it appear? How big is it? Is it noticeable or is it hard to see? You have to scroll down to see it. And a lot of times people just don't do the homework and the legwork to get a good detailed list of services that are actual compensable services and that are specified with enough detail that someone could actually perform an analysis of the value of those services. Too often it's, well, they want this number a month, so we're trying to back into that. I said, you may not be able to, depending how big that number is, but if you want to get to a number, you gotta do the work. Now, final thought I'll leave you with, then we open it for questions, is I like to think of advertising and marketing. Marketing, too much to me, is the concept of one person promoting the use of another person. I rather have it that you, real estate brokerage firm, have a website, have newsletters, have yard signs, have all these other things where I would like to place advertisements for me, and I'm willing to pay to do that. When you go to your local newspaper or you go to a website, let's say of your paper, you know that's not the paper endorsing the advertiser. You know the advertiser paid money to get there. That's how you have to think. That's why I like the term advertising rather than marketing. Whereas I'm using the marketing term, I'm paying for impressions. Impressions are consumer eyeballs seeing my ad. And I'm paying. And if you have your lender, your title company, obviously people visiting the website of a real estate brokerage firm, those are people who are likely going to be client, need your services. So that's a good place to have advertising. Those type of agreements are fine. Or you could jointly advertise in third-party media. Those are the simplest generally. You just go together, you pool your resources, you buy ad space in a local newspaper. That's real easy. The paper established the price of the ad, you split it 50-50 or however you want to do it. You each get corresponding amount of space based on prorated what you paid. That's fine. And there's nothing wrong with that under RESPA in those cases. But that's why I like to leave you with think of the concept of advertising, not marketing. With that, Jeremy, I know we wanted to leave about 5 minutes or so at the end to address any questions that might come in, and certainly happy to do that. While we're waiting, I will note, people are wondering, this Bureau obviously is fairly active. It is regularly making statements. It made a lot of, particularly as we were talking about earlier with that junk fee request for information, it made some very uncomplimentary statements about mortgage lenders and the title industry, which still have me rattled. But in general, so far, we have not seen great aggressiveness in the RESPA Section 8 area. And I always say so far, the trouble is when they're doing investigations, they're not public. So things could be percolating or simmering, not in the public view. And then that's how suddenly you'll get a whole rash of enforcement actions because they were percolating along for a while and they all, they came to fruition all at once, and then people start running for cover when it may be, sometimes then too late. But this bureau, I'd say we don't know. People ask how are they in RESPA? I said I think the jury's out. We still don't know. They've got a lot on their plate. There's a lot of other things they're paying high attention to. We know in our neck of the woods, mortgage servicing is one of the things I like to focus on. But I will say this bureau is not a fan of the title industry. And so that gives me some concern because they can't, they're pretty limited in what they can do with the title industry because, as you know, insurance is mostly left to the regulation of the states, but they have RESPA. And so that's always a concern. Will they try to use their RESPA club to get at the title industry? They clearly in the TRID rule tried to get there by separately identifying title and having to label owners as optional and doing a cockamamie way to disclose insurance when you have simultaneous issuance. That's just a nuts way of doing it. But it was all done because they don't like the title industry, and so that's why we got those crazy provisions and those statements about title fees in connection with the junk fee request for information, which we think that they're going to use that as AstroTurf, generate a lot of comments to then justify taking action. And if their intent was to generate a lot of comments, it worked because they got nearly 2.6 million comments, mostly one paragraph comments from consumers saying the same basic thing or repeating very similar themes. But we're a little concerned that they're going to use all of that as justification to try to venture into areas where it's questionable they may have authority to venture.
Yeah. All right, Rich. We do have questions popping in. Great information on RESPA compliance and what's allowed, what isn't in regard to fees. Several questions on kind of follow up to seminars, legal or not, and also questions about the friends and family program. Why exactly would that be prohibited to have one person refer their family and friends to title company?
They can refer. You just can't compensate them for doing it. And what a lot of people believe is that you could pay a consumer anything, and you could pay the consumer who is hiring you, under RESPA, but you can't pay them to refer their neighbor or their family member. And particularly with state anti-rebate and anti-inducement laws, you often can't pay anybody to suggest someone uses you because the anti-inducement provisions are often much broader and more restrictive than RESPA Section
8. Okay. How about if a title agent's underwriter, can the underwriter provide CE for realtors for free, or would that also be a violation?
Yeah, I think it's an area, I think it's dangerous to get too risky. One thing is it's something that the state regulators that I found actually look for. And I found them, the letter comes into the agency. We have determined that you're doing X, and we think that's a violation. And then you're in discussions with it. So it's an area, if they're going to charge fair market value for it, I think it's fine. Often they don't want to charge anything, and that's an issue under RESPA, even if the underwriter does it. And the trouble is the states look for it. That's another danger factor there.
Okay. All right, we'll try and get through a few more of these. If we don't get to your question, Rich's contact information is on the last slide, email and phone number. So please feel free to reach out to him. You can also reach out to myself as well. My email is jyowie@alta.org. before we get to the final few questions, do want to just remind everyone today's webinar is being recorded. You'll get a link to the recording tomorrow, as well as a link to download a copy of the presentation. And in the chat box is the link to submit your information for CE and CLE. One more follow-up on seminars or courses. What do you think of providing an educational course to real estate agents that is not for CE, such as a course in meditation, for example, or a course that was previously for CE but no longer qualifies?
Yeah, and it's an area, again, the facts are going to matter. It comes down to if it's really done as a promotional event for you, and it's not really focused only on referral sources, that there's a broader invitation. Those are the things you want to do to put you more, and it's probably okay, where you're seeking a broad audience. That may be people who send you business today, maybe people who don't. You might like that they did, so you're trying to get exposure to them. And the event's really done to promote yourself, not give them something of value. That's the area you want to head down. Again, the facts have some more details I didn't get into. I commend you to read those. I think that'll be helpful in showing you how the Bureau would look at these type of events.
Okay. All right, and this was an interesting one. In states where there are split closings, what about splitting the retained premium between the buyers and sellers, title agent and settlement agent?
Yeah, and of course there's state law going split closings, things like that. Pretty much for RESPA, the issue is if you get paid based relative to the services you perform. So let's say there's core title, one side does half, one side does the other half, and you each get half. That would be the RESPA analysis, is are you getting paid something that's commensurate with what you did? Then you have to also though make sure that's okay under state law, because here's where it's you have something could be okay on RESPA, state law might say no, you can't do that. So really there you got to look at both areas of law. RESPA is going to come at it from the point, did you provide enough services that core title service doesn't get to two parties being involved. It was more worried about the case where underwriters were really doing most of the work and still paying the full commission split to the agent. That's what that guidance was more focused on. It didn't focus on two agents doing all the work, but I think if two agents do the core work, they can share commensurate with the amount of work they performed.
Okay, all right, very good. Thank you, Rich. That will wrap up today's presentation. We do need to thank AccuTitle once again for sponsoring today's webinar. Richard, thank you again for joining us and sharing your RESPA expertise. Hopefully everyone definitely got the highlight there of better to think of it as advertising as opposed to marketing, and provide the details. So with that, take care everyone, and have a great rest of the week. Thank you.